Good afternoon, everyone. Thanks so much for being here and online. We're happy to have you. I'm excited to share with you about privacy and cybersecurity diligence, some best practices on that, and some other considerations around that topic. I practice primarily in privacy. At Gartner, we do a lot of work with HIPAA-covered entities, business associates, and all other aspects of privacy. As you know, there's a number of laws, whether it's GDPR in Europe or state laws, the CCPA and others that directly affect our clients. So we're involved in advising on those. So let's dive in here. So just to give you a little bit of a background on what's happening in privacy, I'm going to do a little landscape kind of, what is going on around the US in particular. A lot of things are happening, so we'll talk about that briefly. Just to give a snapshot, we'll talk about some impact on M&A that has had and will continue to have. And then we'll also talk about what are some pitfalls that might come up during an M&A process, whether that's pre-close, during diligence, and so forth. How to avoid those pitfalls, and then get into some examples briefly of things you might ask or might be asked if you're on the selling side as you go through diligence. Then some quick takeaways. So just to kind of give some context, there are several state laws in the US now that cover comprehensively all personal data. Generally, they accept HIPAA-covered entities and so forth, but pretty much all personal data. We've seen those in California, Utah, Virginia, Connecticut. The list goes on, Colorado. And in the past couple of months, we've also seen regulations finalized in California and Colorado. A law in Iowa passed as well and signed into law. So there's a lot of action on this going on. And on the addition, just the past 2 weeks, we've had Tennessee pass a new comprehensive privacy bill. Texas almost passed one. You'll see in your printed slides that we initially thought it was passed, but there was some correction. They actually went back to the House for additional amendments. But again, lots of activity going on. Washington State just passed the My Health, My Data Act a couple of weeks ago as well, which is designed to kind of correct the gaps that HIPAA creates around patient privacy that's not covered by HIPAA. So there's a significant shift that's happening in the US in particular right now around this. We don't have any clear sign of a federal law. We thought we might have one as recently as last year, but it's just the traction has not happened to get that to happen yet, but we'll keep an eye on that. And obviously, cybersecurity is always a hot topic. We never seem to get away from that. Breaches continue to occur regularly. In fact, according to some research, we've hit recently, at least in the past few years, really a high in March this year of cybersecurity attacks. And healthcare is obviously a very valuable sector for those attacks, so that continues to be a major area of risk for healthcare companies. Just a couple of examples of recent breaches in the healthcare space. I think it's helpful to think about these, even though we know they happen, but just to remember these continue to happen. It's the reality. They're very expensive. Average cost, according to recent research, for a healthcare breach is over double other breaches in other sectors, simply because of the sensitivity of information, the requirements around reporting and investigation and so forth. As much as $10 million is estimated on average to the cost of a data breach. And obviously, that'll be affected by a lot of factors. So in these two cases, we had one in the District of Columbia, the health exchange there, where the insurance exchange, there was a breach of those records impacting even congressmen. So the FBI was involved reportedly in investigating that. Significant breach. And then also in February, Sharp Healthcare in California also had a breach. In that case, it was essentially a website vulnerability that led to billing-related information being exposed. So it wasn't all of their patient information, but certain records tied to that website. So again, it's an all-encompassing cybersecurity program is necessary to deal with some of these risks. So what does this all mean for M&A? There's a lot of privacy and cybersecurity things happening, but what about how does that impact the M&A landscape? So on the first bullet here, you'll see obviously, really obviously, I think we all think about breaches. We think about non-compliance with all of these privacy laws. Those create risk, right? So there's the risk of enforcement post-close against the acquiring company, and how does the liability for that play out? There could be valuation or risk allocation issues that are directly impacted by maybe privacy gaps. There could be immense costs to remediate some risks. There might even be devices or products that are impacted by vulnerabilities or security risks or privacy issues. There could also be a significant cost to remediate those. So those, if they're unexpected, that could significantly affect the acquiring company and the value of that deal for them. There might also be unexpected data use limitations. So you may find that an acquiring company is looking at a target, and maybe a particular asset is data that they've collected or processed, clinical trial data, other data, maybe a CRM. What if that was not collected lawfully? Maybe the consent doesn't permit the company that's being acquired to offer that data up to the acquiring company. Maybe there's a lack of consent to that processing. Or maybe the intended purpose for that data that the acquiring company has isn't congruent with the consent that's been signed. Those can all create issues. Product or IT system vulnerabilities. So if you have a medical device that is a connected device, significantly increases the cybersecurity risk. Or maybe there's a product that's a service, so it's hosted online in Amazon or some other web service. Those products, if they're not secured properly, could be significantly devalued by a security incident or a lack of controls there. So you can see how there's a significant impact to M&A from these rules and from these risk areas. So just to give some examples, I think most of you are probably familiar with these companies, but there's a major, these are just major examples of how privacy and cybersecurity have impacted deals in the past. And no doubt there are dozens of other impacts, but these have made the headlines. In one example, Marriott decided to acquire Starwood Hotels. In that process, they did diligence, they did their normal activities. And it wasn't until the 2016 acquisition and then 2 years following that Marriott, I assume, had implemented enough controls to identify that there had in fact been a breach in 2014, prior to the acquisition occurring. And when they finally discovered it, they had to report it, and since then there's been ongoing litigation, enforcement actions, and so on. It's been costly, to say the least. We'll talk a little bit about some ways that those kinds of risks might be mitigated, even if you can't necessarily get the fact that a breach occurred from the party if they don't know, but you can get into some of the controls there. Similarly, Yahoo was acquired by Verizon in 2017, and I think this is illustrative of just the kind of impact that these vulnerabilities and in this case, data breaches can have on the value of a deal. In this case, it was an 8% discount, $350 million of a major deal because of 2 data breaches that Yahoo had to disclose to Verizon during the diligence process. And in addition to that, cash liabilities were split related to the ongoing litigation that would occur afterwards. So there's almost always consumer litigation following a breach, and this is one example of that. So both of these, I think, are showing us some things that we can think about as we dig into what would be good diligence to address these issues. What are some pitfalls, then, that might come up if we were to go into one of these deals without kind of thinking through all of those ramifications? Are we asking the right questions? Are we digging into the details of maybe key risk areas? What if there's a key asset that the company that we're looking to acquire, the target company, have we considered what those risks might be and how to address them in diligence? Have we valued the controls themselves and the implementation of those controls? Or are we only looking for data breaches? If they say, well, no data breaches, are we good? Probably not. We'll talk about that more. But there's a lot of risks that are elevated when the controls are weak. For example, not knowing that a breach even occurred. That may also lead to costly remediation and so on. Also, not understanding the data and how the data is flowing within the organization that's a target could lead us to not know whether that data is usable, what it's usable for, what sort of controls are in place to process that data, whether it was even legally acquired in the first place. Those sorts of questions should be considered in the process of thinking about M&A. What about third-party relationships? Do we ask about those? What if there's a key or critical vendor that supports a product or a service or an operating element of the business that's critical? Do they have the right security and privacy controls? Has that been discussed? So if we kind of miss any of these, obviously there's the potential for significant risk for the acquiring company. So what are some things we can do to avoid these risks? I'll go through 6 different things that I think are really the highlights or top priorities to think about when you do this sort of activity. So obviously you need a team that's going to know what they're doing and what they're looking for. But along with that, you have your IT, your privacy counsel, your cybersecurity experts, those folks that can think through the details of these questions and what the risks might be, but also communicate with that team what are the goals and strategic targets of that acquisition process, because ultimately they're going to look at what they think is valuable or high risk to the company. That might be general program things. It might also be product specific. What if there's a specific product that's the target of the acquisition? Is that product secure? Is it set up properly under a privacy program? Understand the target company's risk profile, and this goes directly to what level of diligence will you do. So is there large repositories of health information? Is it a company that's involved in, say, a reimbursement support program where there's significant patient data? How is that set up? Is it lawfully organized? What about a product that is in the cloud and involves direct access to patient information on an ongoing basis? That could be directly relevant to the risk profile of that company. Are they operating in jurisdictions across the globe, or is it local, in the US only? Do they have are there ducks in a row around those topics? So all of those things could affect the risk profile and should be considered when you scope then how that diligence is approached. So depending on that risk profile, you may want to dig into, deeply into certain categories of questions and inquiries. I'll give some examples of those shortly. Or you might simply want to give a shorter list or more broad questions if you find, okay, this is a low-risk target. If it's a high-risk target, there's going to be a lot more interest, I think, in interviewing, say, the Chief Information Security Officer, Privacy Counsel, folks who are in the know or understand the company's risk internally a little bit better and can speak to those things. Obviously, you'll want to look more at the policies and procedures as well, more deeply, especially if it's a high risk target. So we'll also want to focus those diligence efforts then on the key kind of assets or the operational aspects of the business that are most critical. So you might look at specifically if there's, say, a set of clinical data that's embedded at the company that is part of the value of the acquisition. What if that data set isn't usable? I've run into this where post-close, you're asked, okay, we have this patient consent and we have this set of data and we want to use it for X. And you have to evaluate, okay, is this consent going to allow you to do that? Or was it limited to that original study and that's it? So there's some risk around that, and diligence efforts can only look at those things if the person doing the diligence knows, oh, this is what the purpose of the acquisition or one of the targets of the acquisition involves. So that's key as well. Additionally, I think a key question is always to not only understand whether breaches have occurred, but also what sort of security incident response framework is in place to detect those incidents. If there is a framework, has it ever been used? Are there any examples of it? Has it been tested? If it's not used, that's obviously a red flag that maybe they don't even know if they have breaches. Again, harkening back to the Marriott Starwood example. Look at the key documentation that the company has in place, ask for the privacy policy. And I stop on that term. We often think of privacy policies as, okay, I go to the website, I scroll down to the bottom, and I ignore these all the time. But you click on the privacy policy, and then you read, we value your personal information. We love you because you're a customer. We take care of your data, all those things. We practice good security principles reasonably, the lawyers say. So all that stuff is in there. Is that enough? Generally, no. So if we're asking about a company's privacy program, we want to understand not what they tell you they do, but what is their internal policy, their procedure that governs that program. So if I'm in marketing, what is it that I have to do? What process do I have to go through to collect 50,000 patients' information and run a campaign? What sort of privacy implications will that have inside the company? So that's what you'd be looking for, is things like that, documentation like that. It should reference applicable laws, things that speak to the company's understanding of where they are, what their risk profile is themselves, and gives you a clue of, okay, they actually are doing what they need to be doing. Other than that, going deeper than those written documents, yes, they might have a great program on paper. I'm also looking into, do they actually do these things? They might say they do regular, audits, penetration testing, whatever it is in their policies and procedures, but you can ask for artifacts to prove that. Do they have a scope and date of their most recent pen test for a key product or system? They won't give you probably the findings from that pen test, but they'll tell you, yeah, we did one. They'll proudly say, we did it on July 1st, 2022, and here's the scope of that audit. If they don't have it, you'll find out. Also, you can easily look at key data protection language in contracts, whether it's with vendors or customers. You can understand, are they promising things to customers in their products and services agreements that they can't comply with based on your other diligence? Those things can become critical risks if their customer base is, 50 major health systems and they aren't compliant with those agreements. That could be a major risk in going into that acquisition. So a few other considerations. You might go into a deal thinking, we'll purchase the company and the data will just flow right into our hands. We'll be in control, and from that point on, we're the data controller. But what if there's some services in the meantime that this acquired company needs to provide? So maybe they're in the middle of maybe transitioning data from one data store to another. Maybe there's some unification of data sets that needs to happen. So you need a services agreement. But what if now that company, are they the data controller? Are you the data controller? Many privacy laws have that principle now, even in the US. So is there proper language in place now to deal with that? Reps and warranties, we've all talked about those a little bit, but from a privacy standpoint, are they consistent with the risk profile? So if you've evaluated what laws apply to this company, what sort of risks are present from a data breach standpoint and so on, does the rep and warranty align with that? Or are there missing pieces, as Mark mentioned in his presentation? Also, a big issue is who's liable if there is a breach? The title of this presentation is Whose Data Breach Is It Anyway? And the key question is, whose is it? You may not know unless you carefully think through, how is this structured with an M&A attorney? How is this structured so that the liabilities aren't solely on me as the acquiring company afterwards? What if we do all this diligence and they don't disclose a breach? Are we responsible then? Make sure that you have coverage, at least to mitigate some of that risk, although you won't be able to probably eliminate it. Then finally, what about integration of the company's privacy or cybersecurity programs? Well, what will that cost? What parts of the target company's remediation should occur pre-close? Maybe there's some things you feel like they need to do before you close, and should you hold them to that? We've seen examples of that with clients where the strategic's talking to them and they have to get their ducks in a row before the strategic will sign the papers. So there's some situations like that as well. And ultimately, how will you structure the programs that you have in place to make sure that the acquiring company and the target company can mesh well afterwards, plan for that, because from a privacy and cybersecurity standpoint, that can be difficult. Maybe there's a very sophisticated acquiring company and the target company has to get up to speed, and there can be a significant cost in mapping all of the data, inventorying that, understanding where all of those systems are, and if risk assessments, all those things. So there can be a lot of planning involved in that. So just to share some examples, I won't read through these, but there are a lot of diligence requests that we've seen. Usually these get targeted at, say, covered entities under HIPAA. When GDPR is invoked, so there's different reasons why strategics or investors would look at these things. But lots of different questions we've seen come through. Usually these would be questions that you would provide data in a data room, for example, and they'd pore over it, follow up with questions. You might have interviews following that, but this is something that you would look to ask or prepare to be asked if you're on the selling side. So also there might be interview questions, and I think this is a good idea if you're on the acquiring side, is to look carefully at who in the company would be appropriate to interview on the target side. Just would it be the privacy officer? Do they have one? If not, who is responsible for that kind of activity or cybersecurity activity? It's common in small companies not to have a designated by title privacy officer, and somewhat more common but still unusual to have a cybersecurity, a CISO, a chief information security officer. So those titles might not be there, but who is the person that's responsible for this? Is there a structure? Talk through those things and dig in deeper in those conversations. Find out whether the policies and procedures are used. Look at, for example, is there any review of the policy? Was it released 5 years ago and then never touched again? Does it reference responsibilities? Are those people that are referenced actually in the company? Do they have someone that's got the title of privacy officer if that's what the policy references? Look at those things and dig in a little bit. And always dig into data breach issues. Those can be difficult to dig through, but if there's no cybersecurity incidents at all that the company can report, that can be a problem, just because almost every company has something that has occurred if they have a process to identify it. But if there's no process, it's very likely they will say, well, nothing's happened in the last 5 years, and that's a rarity. Generally, something's happened. So just to wrap up briefly, again, understand what is the risk, the profile of that company that's the target company. More and more, I think that risk profile is going to broaden to the point where most companies have some level of risk around privacy and cybersecurity. Probably lower, of course, with, say, it's just a manufacturer that's building a product and selling it directly to hospitals. But more and more, even those companies will be carrying lists of consumer data, things like that, clinical trial data, et cetera. You might also, you should also have the right people in place. Just make sure that the team that is assembled aligns with that risk profile so that you actually have the right questions being asked. Also make sure that the key risk areas, those areas that most likely would impact the deal or the value of the deal or create risk for the company down the road, are focused on. Go deeper than just the written policies. Make sure that there's any sort of artifacts that you can look at, whether it's consent forms or data protection agreements, et cetera, that those are looked at as well. And finally, I think this is one of the most critical things, of course, but just who is going to be liable if there is a data breach or some non-compliance. Confirm that is addressed. Work with your M&A attorneys and privacy attorneys to look through those details, because that really can be a significant area of risk. And diligence can help, but it can't completely negate those risks. That's it from me. Any questions? All right. Perfect. I'll hand it off to the panel. And Mark.